Well, good morning, everyone, and welcome to today's webinar. Just to start off with a bit of housekeeping, this is a pre-recorded webinar and it will last for approximately 1 hour. By way of introduction, I'm Richard Wolfe and I'm a partner and the head of the Insolvency and Restructuring team here at Myerson. I'm joined today by two other members of the team, Vicky Biggs, who is a legal director, and Jack Ramsden, who's an associate. If there are any questions that you have arising by the end of this session, please feel free to get in touch directly. Our contact details are shown on the slide. So, by way of a brief agenda, we'll be covering the following topics during today's presentation. First of all, administration or liquidation and making the right call. Secondly, restructuring plans versus CVAs, including consideration of strategic use cases following recent decisions. And finally, an antecedent transactions masterclass, including transactions at undervalue, preferences, and beyond. So, without further ado, I will now hand over to Jack for his part of the presentation.
Hello, everyone. I will be discussing the legal and practical points in relation to the question, when is administration the right option, and when is liquidation the legally safer and more appropriate route for a company in financial distress? In considering that question, I will look at the following: the objective statutory test for administration, the pros and cons of both pre-packaged and trading administrations, marketing and creditor transparency obligations, and when, from a legal risk perspective, liquidation is the more appropriate option. The question is not whether administration is more commercially attractive than liquidation, but rather it is whether administration is legally defensible if challenged. For the purposes of this webinar, a base level of understanding of administration and liquidation is presupposed. Administration is a formal insolvency procedure which is intended to support business rescue. It is largely governed by Schedule B1 to the Insolvency Act 1986, which sets out two statutory requirements, being that 1, the company is or is likely to become unable to pay its debts, and 2, the administrator reasonably believes that the statutory purpose of administration is likely to be achieved. The analysis must be considered as at the time of the appointment of the administrator and not retrospectively. Considering the first of the two requirements, the company must be insolvent or likely to become insolvent. Whilst it may be easy to assume or overlook this insolvency limb in respect of a company in financial distress, that approach is inherently risky, and instead, proper analysis of a company's solvency is required. In establishing a company's insolvency, one of the circumstances in Section 123 of the Insolvency Act 1986 must apply, which can essentially be distilled into two tests, being the cash flow test and the balance sheet test. Cash flow insolvency is where it can be proved on the balance of probabilities that the company is unable to pay its debts as they fall due. The test can take into account prospective or contingent debts that will fall due in the reasonably near future, with the meaning of reasonably near future being case specific, as in the case of Re-Sheen Finance. Balance sheet insolvency is where it can be proved on the balance of probabilities that the value of the company's assets is less than the amount of its liabilities, taking into account its contingent and prospective liabilities. In the case of BNY Corporate Services and Eurosale UK, the Supreme Court held that balance sheet insolvency is not purely a mathematical exercise, but must consider the company's circumstances as a whole. Now considering the second statutory requirement for administration, the administrator must be of the opinion that the statutory purpose of administration is reasonably likely to be achieved, which is set out in paragraph 3 of Schedule B1 to the Insolvency Act. Paragraph 3.1 provides that the administration of a company must aim to achieve one of the following objectives. A, the rescue of the company as distinct from the business carried on by the company as a going concern. Or B, the achievement of a better result for the company's creditors as a whole than would be likely if the company were wound up without first being in administration. Or C, the realization of some or all of the company's property to make a distribution to one or more secured or preferential creditors. The statutory objectives are hierarchical, meaning that an administrator must attempt to achieve the objectives in order. Accordingly, the administrator must pursue the primary objective unless they believe that it is not reasonably practicable to achieve it, or that the second objective would achieve a better result for creditors as a whole, and so on. However, there is no need to identify in advance which of the statutory objectives the administration will achieve, as confirmed in the case of Hammond and Profit USA. The administrator's reasonable belief that the statutory purpose of administration is likely to be achieved must be objectively justifiable at the time of their appointment. In the case of Harris Simons Construction, it was emphasised that there must be a real prospect of achieving the chosen statutory objective. Where an administration is challenged, whilst the court would not ordinarily challenge the choice of statutory objective unless it was perverse or made in bad faith, the court will apply a more objective standard when assessing the reasonableness of the methods adopted by the administrator to pursue the chosen statutory objective. And this is where challenges may arise, particularly in pre-packaged administrations, which I will shortly discuss. The court will interrogate the evidence available as at the date of the appointment of the administrator, including cash flow forecasts, the funding position of the company's trading viability, stakeholder support, especially that of secured creditors, creditor pressure, the valuation of the company and any marketing undertaken, consideration of alternative options, and comparative analysis as to whether administration would achieve a better result for the company's creditors as a whole than liquidation would, in line with the second statutory objective. There are examples of cases where the court has scrutinised comparative liquidation outcomes, including in the 2018 case of Bennett and Bosco Investments, and so it is important that a comparative exercise is carried out properly and evidenced prior to administration. It is therefore vital that the decision-making process is documented at the time of the administrator's appointment, which supports the decision to pursue the chosen statutory objective. I will now consider two types of administrations, being pre-packaged administrations and trading administrations. First, I will discuss pre-packaged administrations, or pre-pack administrations as they are often referred to. A pre-pack is a process through which a company is put into administration and its business and/or certain assets are sold to a purchaser immediately upon the administrator's appointment or shortly thereafter, and that is pursuant to a sale that was negotiated and arranged by the administrator before they were appointed. They are often used where it may not be possible for the administrator to continue to trade the business until it is sold at a later date, or the company is otherwise restructured. Pre-packs are common and efficient in terms of restructuring strategy and can be completed within a relatively short period of time. However, they can also be perceived as being controversial. The benefits of pre-packs depend on the exact circumstances, but I'll now take you through some examples. So a pre-pack sale can result in the quick and relatively smooth transfer of a business to a purchaser, compared to a sale negotiated at length following the commencement of administration. The speed of pre-packs can preserve ongoing trade and can minimise the erosion of the insolvent company's goodwill and value. And they can also reduce the cost of the administration process, which would ultimately result in a better return for creditors. The pre-packs can also minimise reputational damage for a company's business and the erosion of the confidence of a company's suppliers, its customers and employees that is inevitably caused by a formal insolvency process. A pre-packed sale may save more jobs for employees than an administration that attempts to continue to trade the business pending a later sale or other type of restructuring. And a pre-packed sale provides more certainty for secure creditors in respect of any return that they are to receive. In appropriate cases, pre-packs can genuinely maximize the value of the insolvent company's business and assets. So as I have said, pre-packs can sometimes be seen as controversial, and I'll now take you through some examples of the main criticisms and legal risks. First, there is a perceived lack of transparency for unsecured creditors. Unsecured creditors often do not realize that a pre-packed sale is going to happen until it has taken place. By contrast, secured creditors are usually involved because they usually need to consent to the release of their security where secured assets are to be included within the sale. Second, there is a perceived lack of accountability on the basis that the administrator has the power to sell the business and/or assets of the company before the administrator's proposals have been agreed by creditors and without court sanction. However, the regulation in this area of insolvency practice makes this less of a concern, which I'll touch upon later. The next example is connected party transactions, where the purchaser in a pre-packed sale is connected with the company entering administration. For example, where two companies have the same directors and/or shareholders. The definition of connected person is set out in paragraph 60A of Schedule B1. This can create distrust between creditors and administrators, and it can be viewed as unfair by allowing the management of the insolvent company to purchase and carry on its business whilst burying the debts and liabilities of the insolvent company. This is viewed as being similar to the outlawed practice of creating a Phoenix company. Connected party pre-packed sales may therefore result in sale at undervalue allegations and misfeasance or breach of duty allegations. And to alleviate this, there are strict regulations in place that must be followed. And it is worth considering those regulations briefly now. So pre-packs are governed by the Insolvency Act and the Insolvency England and Wales Rules 2016. They are also subject to additional regulation, including Statements of Insolvency Practice, or SIPs, and for connected party pre-packs, the Administration, Restrictions on Disposal, etc. to Connected Persons Regulations 2021, which I'll simply refer to as the regulations. SIP 16 applies to all pre-packs and sets out the standards that insolvency practitioners must follow, and includes the information that the administrator must disclose to creditors within 7 days of completing a pre-packed sale. This includes providing a detailed explanation of and justification for pre-packed sale to enable a reasonable and informed third party to conclude that the sale was appropriate and that the creditor's interests were properly considered. That involves the disclosure of specific information to creditors, including the identity of the purchaser, details of any valuations and whether the valuer was independent, alternative options considered and the reasons for not pursuing them, the sale consideration and terms of payment, details of any security taken by the administrator for deferred consideration, or an explanation if none is taken, and confirmation as to whether the purchaser is a party connected to the company. The administrator must also confirm the statutory objective pursued under paragraph 3.1 of Schedule B1 and demonstrate that the outcome achieved was the best available outcome for creditors as a whole. Compliance with with the prescribed marketing standards must also be explained and the marketing strategy justified, and I will say more on marketing shortly. Although SIP 16 is not legally binding, failure to comply with it can result in regulatory or disciplinary action against an administrator. Where the purchaser in a pre-packed sale is a party connected to the company, then SIP 13 of the regulations also applies, and SIP 13 to some extent overlaps with SIP 16. For disposals of a substantial part of the company's business or assets to a connected person within 8 weeks of the start of the administration, which includes pre-pack sales, the regulations require either prior creditor approval, which is often not practical due to time constraints, or a report by an independent evaluator commissioned by the purchaser on whether the grounds and consideration for the sale are reasonable. If the administrator proceeds with the sale despite a negative evaluator's report, they must provide detailed reasoning to the creditors for their decision. So now considering the marketing obligations further. Administrators have a duty to take reasonable care to obtain the best price for the company's business and/or assets. In terms of pre-packs, as I already touched upon, the marketing standards and obligations are set out in detail in SIP 16 and include the information and disclosure requirements, the marketing standards, and the valuation requirements. The aim is to ensure independence, fairness, and transparency. Compliance with the marketing obligations is central to evidencing that the statutory purpose is met, the outcome is better than liquidation, and the price achieved is reasonable in all the circumstances. A failure to test the market meaningfully may undermine the better result test, i.e. administration versus liquidation, the administrator's justification for appointment, and protection from later criticism. Moving on now to considering trading administrations. So a trading administration involves the administrator continuing to trade the company following their appointment before they arrange a sale of the company's business and/or assets or some other form of restructuring. There are several advantages of trading administrations, which include an automatic statutory moratorium, during which creditors are prevented from taking action against the company, which in turn allows the company to continue to trade. The preservation of the value of the company's business by keeping it operating, and the potential to enhance the value of the company. And this in turn may lead to a better return for creditors than if the company had ceased to trade. It also allows the possibility of the company retaining key employees who may otherwise have lost their jobs. And trading administrations may also lead to the possible rescue of the company by way of, for example, a company voluntary arrangement. On the other hand, there are also drawbacks and risks in trading administrations. And these include the following. For directors, there is a loss of control of the company to the administrator. For the company and the administrator, there is potential of incurring further liabilities to enable trading to continue. There are potential risks in adopting employment contracts in the administration. And there is also potential health and safety exposure. A key risk is the personal liability exposure for the administrator, which they will be keen to avoid. There is also the potential for the process to be very expensive, with professional fees reducing any distribution available for creditors. And finally, there may be funding issues given the company has entered administration, which may hinder trading. So the key point here is that the administrator must be satisfied that trading the company is likely to improve the position of creditors as a whole and not materially prejudice the administration estate, or else the better than liquidation test may not be met. I'll now move on to consider whether liquidation may be more appropriate than administration from a legal standpoint. Unlike administration, liquidation is a terminal formal insolvency procedure. And liquidation in this context is either creditors' voluntary or compulsory liquidation. There are several circumstances where it may be considered more appropriate for a company to be placed into liquidation rather than administration. So where there is no realistic prospect of rescue by way of a going concern sale or other restructuring, then the administration may fail the statutory purpose test in relation to the primary and secondary objectives. If the sole objective is to realise an asset for the benefit of a secured or a preferential creditor under the third statutory objective, and there is no material better outcome in administration, then liquidation may be more straightforward and less vulnerable to challenge. Where there is little or insufficient funding, then liquidation may also be more proportionate given the higher cost of administration. Where there are serious director conduct concerns that will need to be investigated, for example, in relation to wrongful or fraudulent trading, then liquidation may be preferable as a liquidator's investigatory function is clearer and less commercially conflicted than an administrator's, given an administrator's prior professional involvement with the company. And where the principal value of the company lies in a cause of action of the company, for example, in claims for preference, transactions at undervalue and misfeasance, then liquidation may be procedurally and strategically preferable, and the liquidator will arguably be less commercially conflicted than an administrator would be. So in summary, when assessing whether administration is more appropriate than liquidation in a particular scenario, the following questions should be asked. So 1, is the company insolvent? 2, which statutory objective applies, and is it objectively supportable? 3, what evidence supports the better than liquidation comparison? 4, has genuine market testing occurred? 5, is trading funded and will value be enhanced in a trading administration? 6, is liquidation simpler, cheaper, and less vulnerable? And if so, then why is administration a more viable option? And 7, how would this decision look under judicial scrutiny? The directors and insolvency practitioners' reasoning should be properly and fully documented contemporaneously. Administration is often commercially attractive and is a powerful insolvency process, but not always the correct one. If rescue is fanciful, funding is weak, or scrutiny is inevitable, then liquidation may be the safest statutory route. The right decision is not about optimism, it is about statutory compliance and legal defensibility. So that's the end of my section of this presentation. I will now pass you over to Richard. Thank you.
Thanks, Jack. Well, my focus today will be recent developments in the use of company voluntary arrangements, CVAs, and Part 26A restructuring plans, which I'll refer to as RPs. I will assume that those watching already have some knowledge of both processes, including their key features. I will aim to cover the following. First of all, CVAs as the restructuring tool of choice, especially with certain liabilities, how that's been affected by the introduction of the RP, key differences in how the two processes operate, and how that affects when they're used. Secondly, a review of how the courts have been applying the cross-class cram down and takeaways for companies looking to use an RP and the way in which creditors to respond to the use of the cram down. Then when RPs could, at least in theory, work well for SMEs, and whether we are likely to see an increase in their use by SMEs. Also, lessons from challenges to CVAs in the retail and hospitality and leisure sectors, and how RPs have fared in terms of dealing with certain types of creditors. And finally, some practical points to take on board when advising creditors in relation to both RPs and CVAs. So, the CVA has been around for 40 years and was intended to provide a company with the means of restructuring its debts quickly, cost effectively, and flexibly without the need for court hearings, other, of course, than in creditors challenged the CVA's approval. Once approved by the required creditor majorities, the CVA would then be implemented. The CVA's biggest drawbacks, perhaps, have been its inability to bind secured or preferential creditors without their agreement, and also the possibility of challenge by a dissenting creditor within 28 days of approval through alleging unfair prejudice or a material irregularity in the CVA process. In the years leading up to the COVID-19 pandemic, CVAs were widely used, partly due to deepening economic challenges facing the retail and hospitality and leisure sectors, including a number of national store and restaurant chains. With financial pressures arising from such issues as increasing overheads and competition and the impact of onerous leases, several high street names resorted to CVAs focused largely on the significant reduction of lease liabilities. Many of these CVAs then failed, leading to yet more administrations and demonstrating that the CVAs were unable to address in the long term the underlying structural issues affecting those businesses. Specific challenges to CVAs, such as the Debenham CVA from landlords, also added to potential uncertainty as to their effectiveness in reducing lease liabilities, even where, as with Debenhams, the challenges were unsuccessful. Attempts to remove the protection of parent company guarantees from leases were also seen as controversial. Whilst the PRG Powerhouse case established the principle of guarantee stripping in CVAs as early as 2007, the Miss 60 case in 2010 saw the High Court setting aside an attempt to release a parent company guarantee on the grounds it constituted unfair prejudice. Whilst the impact of the COVID-19 pandemic saw CVAs used to compromise a wider range of liabilities, the reintroduction of Crown preference in December 2020 created a significant obstacle given the inability of a CVA to bind secured and preferential creditors, such as HMRC, without their consent. Where agreement couldn't be reached with, say, HMRC or all tax liabilities paid, then the CVA couldn't be approved. Restructuring plans were brought into being under the Corporate Governance and Insolvency Act 2020. The relevant legislation now forms Part 26A of the Companies Act 2006, and the first plan sanctioned by the court was for Virgin Atlantic in 2020. Key differences when compared with the CVA relate to the process required for the implementation of an RP and that it can be used to compromise secured and preferential liabilities as well as unsecured debts. So first of all, there are two court hearings required for an RP to be approved. One to convene the meetings of all the classes of creditors and members to vote on the plan, the second hearing to sanction the plan. This, along with other requirements in terms of the formation of the plan, provision of information and evidence of valuation to creditors, makes the process both time-consuming and very costly, and has meant that it's mostly been used for very large-scale restructurings. One example being Thames Water, where the total advisory and legal costs associated with the RP were likely to exceed no less than £200 million. The use of the cross-class cram down is a second factor which the court could use to bind dissenting classes of creditors, including secured and preferential creditors such as HMRC, so long as one class of creditor benefiting the plan has approved it, and the dissenting classes of creditor would be no worse off in the likely alternative, usually administration or liquidation. So key factors then as to whether a CVA would be preferable to an RP are as follows. Will there be sufficient creditor support for the CVA? If the required threshold of 75% of debt value for the vote of unsecured creditors is expected, then a CVA may be better. A CVA, of course, requires only one principal vote, aside from the connected party vote, with no separate classes of unsecured creditors. With an RP, each class of creditor needs to vote separately, with a minimum 75% majority in value in favour of the plan, where the cross-class cram down isn't used. The ability to use the cram down to bind certain classes of creditor, for example, landlords, who are effectively out of the money, could be a factor in favour of proposing an RP. Then, of course, there's the question of the timing of and grounds for any challenge. Creditors seeking to oppose an RP will make their position clear at the start of the process and mount any challenge prior to the plan being sanctioned. This has been reinforced following the revised RP practice statement of September 2025, calling for more front-ending of evidence and the airing of issues by key stakeholders. With the CVA, any challenge to its approval will only be possible in a short 28-day window following approval, arguably reducing the potential for challenge. And finally, there's the total cost burden and timescales associated with an RP. And this may weigh in favour of using a CVA where support from secured and preferential creditors is expected and challenges are unlikely. So, how have the courts been applying the cross-class cram down? Well, the cram down is the most significant and controversial feature of the RP, and it's the court's ability to cram down the position of dissenting classes of creditors and to sanction a plan despite clear opposition to it. 2025 saw key decisions regarding the court's approach to the sanctioning of RPs and its discretion in using the cram down. First of all, the Petrofac decision in the Court of Appeal in July saw increased scrutiny in the use of the cram down when the court rejected a plan that had been sanctioned at first instance. The message here, echoing the 2025 Court of Appeal decision on the Thames Water plan and the Adler decisions in 2024, was that creditors who were out of the money in the likely alternative to the plan just can't be ignored, and their interests and contribution to the restructuring should be considered when allocating the benefits under the plan. Further court decisions that have followed this approach relate to the restructuring plans for Waldorf, River Island, Poundland, and Madagascar Oil. So key takeaways from the recent cases that are important for both debtor companies considering the use of an RP and for creditors are as follows. First of all, a company proposing an RP must demonstrate meaningful engagement with creditors prior to starting the court process. The court will look at the evidence of this when deciding whether to sanction an RP. The lack of such engagement was key to the rejection of the Waldorf plan, where the plan company wrongly proceeded on the basis it thought the largest unsecured creditor could be ignored as it was out of the money. Where a company proposing an RP makes a genuine attempt to negotiate with key stakeholders, as in Poundland, where the plan company tried to engage with its largest creditors but was limited in its ability to do so given the urgency of the court process, this can make a difference. The court sanctioned the plan in that instance with 8 separate classes of landlord creditor and the general class of creditors all crammed down. Lack of engagement with the court by creditors opposing an RP can result in their cram down. In the River Island case, there were 10 classes of creditors, 7 of which were landlords. Whilst 2 landlord classes voted in favour of the RP, one of the landlords from the dissenting classes was invited to explain its rejection of the plan. It chose not to engage in this process, and as the court had no evidence of the reason for its objection, and where it appeared to be better off under the plan, this weighed on the decision of the court to sanction the plan itself. In Madagascar Oil, there were only 2 creditors. One of them, which supported the plan, was the company's shareholder. As that creditor was putting money into the company, the court was prepared to treat that creditor differently from the dissenting creditor, although it had the same rank, on the basis that the differential treatment could be justified due to the injection of funds. In the River Island decision, another critical question that was considered was fairness and the value that supporting creditors should give to objecting creditors in order for the RP to be deemed as fair. The court will have regard to the way the RP was developed and will consider whether it was a genuine attempt to find a fair solution to a critical problem, as opposed simply to trying to extract an advantage from a critical situation. Finally, there's the question of how to treat out-of-money creditors, and this is still a contentious one. The early position adopted in the 2021 Virgin Active case and followed prior to the rejection of the Waldorf plan in 2025 was that the views of such creditors who opposed the plan carried no real weight. Since the Waldorf decision, however, the court will now focus around ensuring the cram down is not used to give creditors who are in the money a disproportionate share of the benefits of a plan to the detriment of out-of-the-money creditors. So, cramming down HMRC, well, given the usual importance of HMRC as a creditor, the court's approach to the use of cram down against the crown creditor has been a pivotal issue in the use of the RP. We start then with the Host plan sanction in 2022. Here, HMRC was crammed down, but it didn't attend the sanction hearing to make representations. Moving on then to the Nasmith Group Limited case in 2023. Here, the court declined to exercise its discretion to sanction a plan opposed by HMRC as unfair, as it saw its sanction could lead to other companies trying to use RPs to cram down their unpaid tax bills. Key factors here were, first of all, the size of the Crown liability, second, whether all or part of it was preferential, third, whether the wider group owed a larger amount to HMRC, which it did, fourth, the fact that some of the debts went back over 3 years, and finally, the fact that HMRC was only given a very small share of the restructuring surplus that was going to be available under the plan. Then we have the Prezzo Investco Limited case in 2023. The sanctioned courts here was prepared to cram down HMRC as a dissenting creditor, where almost all the restructuring surplus that the RP would generate was allocated to HMRC following engagement by the plan company to address HMRC's concerns. Well, following on from these various decisions, HMRC then issued guidance in November 2023 on its approach to supporting RPs, the information it expects to receive, and how it will make decisions. And so now, understanding the approach of this key creditor is more straightforward. The Revolution Bars RP sanction in 2024 demonstrated the application of HMRC's guidance as the plan company ensured the tax debt received preferential treatment, previous time to pay breaches were addressed, and demonstrated to HMRC that the business had a sustainable future. Crucially, it also secured HMRC support by deferring, rather than seeking to reduce, £2 million worth of tax liabilities, and by avoiding worse treatment of HMRC as compared with other creditors, aligned itself with HMRC's expectations of the fair treatment of tax liabilities. So the final point here relates to departure in an RP from the pari passu principle, namely that of equal treatment between creditors, without justification for that departure. In 2024, and for the first time, the Court of Appeal overturned the sanction of a restructuring plan which related to the Adler Group. The key point was that the plan revised the terms relating to several series of unsecured loan notes, with one series of notes treated differently with the fixing of a later repayment date compared with the other series of notes. The holders of the notes to be repaid later voted against the RP but were crammed down by the court. They appealed the decision, alleging the plan departed from the pari passu principle in an unjustifiable manner. The court had to satisfy itself that none of the dissenting class would be any worse off than in the relevant alternative, here a combination of insolvency proceedings in England and Germany, under which all the note holders would rank equally. So the takeaways from this point are: plan companies and their advisors should be careful to ensure the proposed ranking of creditors is the same as in the relevant alternative unless any change can be justified. And secondly, the test that the court applies when looking to apply cram down is what a fair distribution of the benefit under the RP should look like. So, assessing when it may be appropriate for an SME to use an RP, there would appear to be three main scenarios. First of all, where the SME has a significant amount of secured debt that requires compromise. Second, where the SME has HMRC secondary preferential debt, taking into account what's already been said about HMRC's position. And finally, where a few dissenting creditors, such as landlords, might threaten to derail the attempt to effect a company-wide rescue. Well, the first real instance where an SME was not already in administration of the use of an RP by an SME is the Host plan that I mentioned earlier in connection with the cram down of HMRC. In that plan, there were a number of classes of creditors and members, but HMRC was the only dissenting class of creditor, and the court exercised its discretion to use the cram down, though, of course, as I mentioned earlier, the plan faced no active dissent at the sanction hearing. Well, one key factor is the overall costs involved with the RP process. Where the court is prepared to take into account the size and resources of the company proposing an RP when deciding whether to sanction the plan and whether all procedural requirements have been met, this could, in theory, enable the use of the plan process at a somewhat lower cost. In the Rehoust case, the court was prepared to be flexible in allowing the plan company a lower evidential burden regarding valuation evidence in support of the RP than would be required from a larger company. Since the Rehoust decision, and whilst the RP has in the main been used by sizable enterprises with complex debt structures and significant numbers of creditor classes, there are examples of SMEs successfully using the plan process, to include Goodbox Co Labs Limited in 2023, which was sanctioned by the court in Leeds, and in 2025, Enzen Global, that received HMRC support for its plan, Outside Clinic Limited, that HMRC actively supported in court, and perhaps most notably of all in terms of size, DST BTD Limited, a talent on demand business with just over 6 million turnover, which used its RP to handle historic tax debts and operational challenges. As for a recent development that could unlock the use of RPs by SMEs, the updated practice statement for schemes of arrangement and restructuring plans was published in September 2025 and came into effect on the 1st of January 2026. Whilst the revisions to the RP process set out in the statement do not automatically make RPs a standard low-cost tool for all SMEs, they arguably improve their accessibility for middle market companies by fostering a more predictable, structured and efficient process, in that they first of all require front-loaded preparation that identifies issues at an early stage, which should reduce the risk of expensive later stage procedural challenges. Secondly, they potentially cater for faster timelines for straightforward RPs with limited number of creditors, which may therefore accelerate court sanction and result in lower costs. And finally, they reduce the documentation required by encouraging more concise, focused and accessible summaries for stakeholders. There are some commentators that argue, however, that the changes in the legislative approach may, at least in the short term, result in more time and cost when using an RP, not less. Watch this space. So, learning then from challenges to CVAs in retail and hospitality and leisure, case law on the use of CVAs in retail and hospitality and leisure reveals the issues faced by companies trying to use CVAs to force compromises on certain categories of creditor. And as mentioned earlier, a CVA can't be used to compromise secured or preferential creditors, including, crucially, HMRC. Key to the fairness of a CVA will be the treatment of different types of creditor, whether any differential treatment has caused unfair prejudice, and whether that unfair prejudice can nevertheless be justified, how creditors would fare in other alternatives, and with landlords, whether they are offered the option to terminate the lease, and the extent of modifications proposed to the lease. So, looking at a couple of key challenges encountered in relation to CVAs. First of all, we have New Look. This was a retail business with some 400 stores. The court here held, following a challenge by compromised creditors, that the CVA didn't unfairly prejudice those landlords' interests. They would have been worse off in administration, and their differing treatment was justifiable, as they were given the option to terminate any leases where they didn't wish to accept reduced rent proposed under the CVA. Secondly, we have Regis. This CVA related to a hairdressing salon group. The landlords opposing the CVA had claimed both unfair prejudice and material irregularity. Whilst most of their claims were dismissed, the court did find that the treatment of a specific creditor as critical, resulted in that creditor being paid in full, was unfairly prejudicial, where there was a lack of sufficient evidence to justify the position. Then we have treatment of a question of whether restructuring plan was just and equitable in both the hospitality and leisure and retail sectors. We have Virgin Active. First of all, the court sanctioned decision on this RP came in 2021 and was in relation to a health club and spa chain. The restructuring had encountered opposition, with less than 75% in value of certain landlord classes supporting the RP. The court sought to determine whether the landlords would be any worse off in an alternative outcome, here a trading administration, as opposed to considering the position of fairness or the RP being just and equitable. Key to the sanction of the plan here was that it was clear that the landlords would in fact not be any worse off under the plan than in an administration, and moreover, they hadn't produced any evidence that they would be worse off. Then we have Revolution Bars. The sanction of this RP in August 2024 demonstrates the effectiveness and flexibility of the RP since coming into being. The business was able to address severe financial distress by compromising significant liabilities, including bank debt, landlord arrears, and lease obligations, right-sizing its site portfolio by exiting 18 loss-making sites and thereby reducing future rent obligations. Key here was the court's view that the RP was not unfair to creditors, including landlords. And finally, we have Poundland. Well, this is a good recent example in August 2025 of a significant retail RP, where the plan was deemed to be just and equitable, as it was the only viable alternative to administration, which have resulted in a worse outcome for landlord creditors than with the reduced rents proposed under the RP. So finally then, some practical points to take on board for advisors when to consider when providing advice to creditors who are looking at CVAs or RPs. First of all, evaluating the relevant alternative. In the context of an RP, being able to identify what a creditor's position would look like in, say, administration or liquidation will be key to understanding if a successful challenge of unfairness can be mounted to an RP, including a deep dive into the plan company's valuation of assets and cash flows, and to sense check any suggestion by the plan company of a low value insolvency, such as liquidation, as the likely alternative. Second, there's the issue of understanding voting thresholds and cram down. Being able to identify the level of creditor vote needed to block a CVA, more than 25% of the creditor vote and or more than 50% of the unconnected creditor vote, or in the context of an RP, needing to identify the various classes of creditor, all of which will require a 75% majority in debt value in favour for the RP to succeed, unless the court resorts to a cram down of dissenting classes of creditor. Then there's identifying leverage and negotiating points. With an RP, first of all, ensure a creditor applies for further disclosure if the explanatory statement provided by the plan company is deficient or lacks a robust valuation methodology. And second, check carefully the way in which creditors have been grouped into classes to ensure there's been no attempt to dilute their voting power. In a CVA, propose sensible modifications that will restore balance to creditor outcomes before the proposal is voted upon or in order to ensure its approval. And finally, check for blots and procedural flaws. It's important creditors understand the timescales involved if they are to exercise any rights of challenge, which is within 28 days following approval of a CVA or with an RP in the immediate period following the launch of the plan or potentially at the sanction hearing, although that's tactically risky. And as regards fairness between classes of stakeholder, creditors should be encouraged to look for deviations from the pari passu principle in an alternative outcome that can't be justified, in the context of determining whether to challenge either a CVA or an RP. Well, that brings me to the end of my part of the presentation. Thank you for listening, and I will now pass you over to Vicky for her part of today's webinar.
Thank you, Richard. In this section of the webinar, I will discuss current trends in claims, how to build strong claims, common defences, and early identification strategies. I will focus on antecedent transaction claims arising out of corporate insolvencies, such as administration and liquidation. Similar provisions do apply in the context of bankruptcy, but these won't be discussed today. I've put on the slide the different types of antecedent transactions which can be brought pursuant to the provisions of the Insolvency Act 1986. During today's webinar, I will focus on transactions at an undervalue, preferences, and transactions defrauding creditors, as these are the most common types of claim. Antecedent claims are often an important part of recoveries, particularly when insolvent companies are often asset light, there are limited recoveries from any trading, and there is growing scrutiny from creditors to achieve the best possible outcome for them. There is a rising volume of antecedent transaction claims which are driven by numbers of company insolvencies. There were 23,938 company insolvencies registered in 2025. This is similar to 2024, where there were 23,880 company insolvencies, but 5% lower than 2023, where there were a total of 25,164 company insolvencies, which was the highest annual number since 1993. While numbers in 2025 were similar to 2024, there was a slight decrease in creditor voluntary liquidations, CVLs, 18,525 as opposed to 18,839. This was offset by an increase in compulsory liquidations, 3,730 as opposed to 3,239, which is the highest annual number since 2012. Administration saw a 6% decrease between 2024 and 2025, 1,495 as opposed to 1,597. Whilst the numbers of company voluntary arrangements, CVAs, were down 8% from 2024 to 2025, 186 as opposed to 202. In 2025, CVLs were the most common company insolvency procedure, 77%, followed by compulsory liquidations, 16%, administrations at 6%, and CVAs at 1%, whilst receivership appointments made up less than 1% of cases. The 6 industries that experienced the highest number of insolvencies in the 12 months to November 2025 were 1. Construction, 2. Wholesale and retail trade, specifically repair of motor vehicles and motorcycles, 3. Accommodation and food service activities, 4. Administrative and support service activities, 5. Professional, scientific and technical activities, and 6. Manufacturing. Before I turn to what evidence is required to build antecedent claims and how claims can be defended, I will provide a quick refresher as to what needs to be proved in order to bring successful claims for transactions at an undervalue, preferences, and transactions defrauding creditors. An administrator or liquidator can apply to the court to ask the court to set aside or make another appropriate order in relation to a transaction at an undervalue if 1. The company made a gift or otherwise entered into a transaction on terms that the company received no consideration, or the company entered into a transaction the value of which is significantly less than the value of the consideration provided by the company. 2. The transaction was entered into during the 2 years prior to the onset of insolvency. In administration, the onset of insolvency is the date on which the application to court for an administration order is issued. A notice of intention to appoint an administrator is filed at court, or the date on which the appointment of an administrator takes effect. In liquidation, the onset of insolvency is the date on which the winding up petition was presented to the court, or the company passed a resolution for its winding up. 3. The company was unable to pay its debts at the time of the transaction, or became unable to pay its debts as a result. This is known as the insolvency requirement. It is for the applicant to prove that the company was unable to pay its debts at the time of or in consequence of the transaction. Where the transaction was made with a connected person, there is a presumption that the company was insolvent at the time unless it can be shown otherwise. Please see section 240 of the Insolvency Act. Connected persons include a director of the company, a shadow director of the company, an associate of a director or shadow director, and an associate of the company. Associates of a director include the director's spouse and close relatives. A person is an associate of a company if that person and that person's associates control it. The analysis of association under section 435 of the Insolvency Act can be complex and require careful consideration. An administrator or liquidator may apply to the court to ask it to set aside or make another appropriate order in relation to a preference. A company gives a preference to a person if each of the following apply. 1. That person is one of the company's creditors or a surety or guarantor for any of the company's debts or other liabilities. 2. The company does anything or suffers anything to be done which has the effect of putting that person into a position which, in the event of the company going into insolvent liquidation, will be better than the position that person would have been in if that thing had not been done. 3. The company was influenced in deciding to give the preference by a desire to prefer the party. If the person is connected with the company, other than by being an employee, it is presumed that the company was influenced by a desire to prefer that person. This presumption is rebuttable. 4. The preference was given during the 6 months or 2 years where the person that has been preferred is connected with the company before the onset of insolvency. The same definitions apply in regards to connected persons and the onset of insolvency, as I mentioned previously in the context of transactions at an undervalue. And 5, the company was unable to pay its debts at the time of the transaction or became unable to pay its debts as a result. Again, this is known as the insolvency requirement. There is no requirement that the company be insolvent or in liquidation or administration for a transaction defrauding creditors claim to be brought. A transaction can be set aside if the transaction is entered into at an undervalue and the purpose of the transaction was to put assets beyond the reach of a person who is making or may make a claim against the company, or to otherwise prejudice a person's interest in relation to such a claim. A general intention to protect assets from creditors who might arise in the future is sufficient for liability. Whether the relevant purpose has been formed is a subjective test. The court has to be satisfied that the person actually had the purpose, not that a reasonable person in that person's position would have had it. A transaction for the purposes of section 423 is very widely interpreted, and it is not necessary for there to be a transaction within section 423 that the debtor must have transferred assets. I've set out on the slide a strategic overview of how antecedent transaction claims should be built. In terms of identifying and evidencing claims, a significant number of data sources which administrators and liquidators are entitled to obtain pursuant to Section 235 of the Insolvency Act will be key. Relevant data is likely to include things like the insolvent company's bank statements, general accounts ledgers, board minutes, cash flow forecasts, management accounts, and email correspondence. Particular red flags to look out for when identifying claims is unusually timed payments, selective payments, and payments made just before the company entered a formal insolvency process. Obtaining proofs of debt from creditors with details of how much they are owed and timings as to when the debt arose are particularly helpful to demonstrate the insolvency requirements. Contemporaneous documents, as opposed to information provided in hindsight, is more helpful. And forensic analysis of documents and data should be done as soon as practicably possible after appointment as office holder. In terms of pleading a claim effectively, this is our job. When pleading claims, the courts expect precision. Vague pleadings are vulnerable to attack and can lead to claims being unsuccessful. For each of the three core antecedent claims, transactions at an undervalue, preferences, and transactions defrauding creditors, the pleading should 1. Set out standing to bring the claim and the onset of insolvency. 2. Particularize the impugned transactions with a clear money or asset trail. 3. Allege and evidence the statutory elements, including where relevant, addressing presumptions for connected persons. And 4. Specify the relief sought. More specifically, for transactions at an undervalue, the particulars and evidence to be set out is the transaction particulars, dates, instruments, consideration promised and actually provided, and a schedule of asset or fund flows. Contemporaneous or expert valuation evidence showing the undervalue. Insolvency analysis, cash flow and balance sheet tests with schedules, and if needed, expert accounting evidence. Where relevant, information regarding connected parties in order to engage the presumption of insolvency. And finally, the facts showing that the transaction was not in good faith for the purpose of carrying on the business, and/or there were no reasonable grounds to believe it would benefit the company. For preference claims, the particulars and evidence required are identification of each payment or act with dates, amounts, and beneficiaries. Producing a schedule mapping out the payments is very helpful. The insolvency analysis, this is the same as I've mentioned previously in regards to transaction and undervalue claims. And finally, the necessary facts supporting the inference of desire. For unconnected parties, this will involve providing details of creditor pressure or demands, the selective nature of payments, and internal communications or board minutes indicating an intention to favour. For connected parties, the statutory presumption should be pleaded together with facts undermining any rebuttal of that. For transaction defrauding creditor claims, the particulars and evidence required are those mentioned previously in the context of transactions at an undervalue, and evidence of the intent to defraud creditors. This can include things like timing of the transaction as against any threatened or actual claims, secrecy, lack of documentation, asset stripping, lack of value, and lack of good faith. Where facts overlap, alternative claims should be pleaded. For example, the same set of facts may give rise to both a transaction at an undervalue claim and a transaction defrauding creditors claim. Also, whilst not covered in this webinar, misfeasance claims against directors often overlap with transactions at an undervalue and preference claims. In terms of recoveries, where transaction at an undervalue, preference, and transaction defrauding creditor claims are proved, the court has flexibility as to what orders to make. Section 241 of the Insolvency Act sets out the orders the court can make upon successful transaction at an undervalue and preference claims being brought. The court may make any order it thinks fit to restore the position to what it would have been if the company had not entered into the relevant transaction. In particular, the court may require any property transferred as part of the transaction to be revested in the company, require any proceeds of sale to a property to be revested in the company, release or discharge any security given by the company, require any person to pay in respect of benefits received by that person from the company, such sums to the administrator or liquidator as the court may direct. And the court may make orders affecting third parties, that is, persons other than those who dealt directly with the company in the transaction, who did not act in good faith and for value. However, where a transaction an undervalue or preference has occurred, a person who did not deal directly with the company and who acquired their interest in good faith and for value cannot be required to pay any sums or have their interest in property prejudiced in any order relating to the undervalue or preference. The types of orders that the court can make on a transaction defrauding creditors claim are set out in Section 425 of the Insolvency Act. These include requiring any property transferred as part of the transaction to be vested in any person. An order under Section 423 may not, however, prejudice any interest in property that was acquired from a third party in good faith for value and without notice of the relevant circumstances or any interest deriving from such an interest, and require a person who received a benefit from the transaction in good faith for value and without notice of the relevant circumstances to pay any sum unless that person was a party to the transaction. The orders the court can make when such claims are proved is only part of the story. Before claims are brought before the court, it is essential to think about recoverability and how any judgment made by the court will be satisfied, particularly those of a monetary value. More often than not, antecedent transaction claims against the director will seek that the director contributes to the assets of the insolvent company's estate. There is little point in bringing antecedent transaction claims if there is no realistic prospect that a director will have the means to pay. I will now move on to discuss how antecedent claims can be defended. In regards to transaction and undervalue claims, the court will not make an order to set aside a transaction at an undervalue if it is satisfied as to both of the following. 1. The company entered into the transaction in good faith and for the purpose of carrying on its business. And 2, at the time it did so, there were reasonable grounds for believing that the transaction would benefit the company. The issue of whether the company entered into the transaction in good faith involves a subjective assessment of the company's controlling minds. However, whether there was a belief on reasonable grounds that the company would benefit from the transaction is viewed from an objective standpoint. To demonstrate good faith, it will need to be shown that there was a genuine commercial purpose for the transaction. To demonstrate the transaction was carried out for the purpose of the company carrying on its business, it will need to be shown that the transaction was aimed at maintaining operations or facilitating a turnaround. To demonstrate reasonable grounds, contemporaneous documents will need to be deployed, such as board minutes, cash flow forecasts, third-party advice, engagement from lenders and/or creditors, and independent valuations evidencing a rational belief in benefit at the time. The 2-year look back runs from the onset of insolvency. It may be possible to challenge the correct onset date and show that the impugned dealing predates the relevant period. The insolvency requirement can be disproved by demonstrating that on a cash flow and/or balance sheet basis, the company was not insolvent at the time of the transaction and did not become insolvent as a result of the transaction. Payment of an existing debt is not an undervalue. To defend a claim on this basis, it will be necessary to precisely identify the debt discharged and its quantum at the time. It may be possible to deny that there has been an undervalue on a proper valuation basis. The relevant evidence must address market value as at the transaction date, contemporaneous market conditions, and the commercial rationale for the transaction. Even if liability is established, relief is restorative, not penal. Relief must not prejudice interest acquired in good faith, for value, and without notice by subsequent acquirers. It may be possible to limit orders to those directly implicated. It may also be possible to challenge the office holder's quantification with a net benefit analysis. Relief is also discretionary. It may be possible to argue that full unwinding would be inequitable or commercially impossible. Defending a preference claim will need to focus on 1. Defeating one or more of the statutory elements of the claim, and/or 2. Limiting or defeating discretionary relief. It may be possible to challenge the better position element of the claim. Examples of this include 1. If the creditor was fully secured at the time, any payment made by the company to the creditor may not have improved the creditor's ultimate position in an insolvent liquidation. The better position test is not met if the creditor would have recovered in full from its security in any event. 2. Payments from monies not beneficially owned by the company, for example, trust monies or retention of title goods proceeds, may not improve the creditor's liquidation position vis-à-vis the company's estate. And 3, where insolvency set-off would have yielded the same result, there may be no improvement on the creditor's position. It may be possible to challenge the relevant onset of insolvency date and show that the impugned act fell outside the relevant time period, 6 months for unconnected parties and 2 years for connected parties. The insolvency requirement is rebuttable. It may be possible to provide contemporaneous evidence that the company was solvent at the time the payments were made and that the company did not become insolvent as a result of the payments. It may also be possible to show that there was no causative desire to prefer. In regards to unconnected parties, it would need to be shown that the operative intention was to continue trading, to preserve enterprise value, comply with lender requirements, or to avoid collapse rather than to advantage the payee in a hypothetical insolvent liquidation. Evidence of things like commercial pressure or supply chain necessity will be key. In regards to connected parties, cogent contemporaneous evidence will need to be provided to show that the company did not contemplate insolvent liquidation and was not motivated by a wish to put the recipient in a better position. Payments made to deal with guarantees, to unlock continued facilities, or to implement transactional steps without contemplation of insolvency can suffice. Even if a preference claim is proven, relief is restorative, not penal. It may be possible to argue for 1. Credit for value given and benefits conferred. 2. Limitation to the net improvement in the liquidation outcome. 3. The protection of third parties so that orders are not made which will prejudice innocent stakeholders down the chain. And 4. The tailoring of monetary relief where the unwinding of the payment would be impractical or inequitable. To defend a transaction defrauding creditors claim, it may be possible to deny that the relevant dealing was a transaction at an undervalue, as already discussed earlier in this webinar. It will be necessary to address head-on any secrecy, insider involvement, creditor pressure, retention of benefit, or asset stripping patterns with cogent explanations consistent with a legitimate purpose. It may be possible to demonstrate that there was no realistic detriment to creditors. This weakens the inference of prescribed purpose and can be relevant to any relief that the court orders. Where possible, demonstrating any significant prejudicial delay can be relevant to the court's discretion to refuse or limit relief. Even if liability is established, relief aims to restore the position so far as practicable. It is possible to invite the court to 1. Credit real value provided and benefits retained by the estate. 2. Prefer monetary adjustments over rescission, where unwinding is impracticable or inequitable, and/or limit any order to the net detriment proved to have been suffered by the identified victims. Early identification of claims is crucial. An early review of potential claims can help in terms of preserving evidence, avoiding limitation issues, improving settlement leverage, and maximising options as to how claims can be pursued and resolved. Early warning indicators of viable antecedent transaction claims include rapid creditor reduction, asset transfers and payments to connected parties, and refinancing on punitive terms. To conclude, antecedent claims are a core recovery tool in the context of corporate insolvency processes such as administration and liquidation. The quality of the evidence is decisive in terms of whether claims will be successful or not. And early identification of claims helps drive positive outcomes. That brings us to the end of this webinar. Thank you for watching. We are not going to be doing a live Q&A session today, but you will be sent a recording of this webinar to watch again and share with colleagues. If you do have any queries about the topics discussed today, please do not hesitate to get in touch with a member of our insolvency restructuring team. Thank you and enjoy the rest of your day.